how much cash bail is he able to afford?
10,000 councils will pay, but free bond. Actually, free bond would be
It's okay, it's okay.
Yeah. But free bond of 1 million.
Your Honor, maybe Your Honor, just before you pen off, my colleagues have made submissions on the issue of bail. I just wanted to go on record that we are not objecting to bail.
We appreciate
You know what?
Maybe on condition that my Vice President ensures that he reports to the investigating officer whenever he's required.
So today's first. I want us to skip tomorrow. You come on 3rd of October. Sorry, no, 3rd of October. You come tomorrow at 2 p.m. tomorrow. Yes.
Is that Thursday?
Tomorrow is Wednesday.
Oh, okay. The court, your Honor is proposing Thursday, the 3rd or tomorrow, the 2nd?
Sorry, the 3rd of October.
Could we go to 4? Could we go to 4 that will give you enough time? In the morning.
Okay. You see, I'm already confused because we don't have fresh. So, ruling on the application to be delivered on 4th of October this year at 2 p.m. I know why I'm saying to have a very long hearing in the morning. And the accused person is granted cash bail of Kenya shillings 50,000 with one contact person to appear before the court on 4th of October this year.
Response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. But the charge sheet itself is indicating erroneous dates when our client was arrested. We say that they arrested him today. And the fact is that they arrested yesterday. They have a duty to disclose all the material facts, and there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you seek to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client forthwith as you discharge him. Most obliged.
DPP.
So the prosecution is done.
Your Honor, we are done. We only respond to the issue of the charge sheet. Okay. The other issue are more constitutional, and as at this point, this court only ought to consider whether the statement of the offense meets the legal criteria and whether the particulars of the offense contain sufficient details.
Thank you.
And I've gone to the issue of the harassment.
Thank you. Yes, Madam.
Martha Karua, SC, leading the defense team. Just to remind the court that our plea is that the charge be dismissed or rejected as defective under 89.5 of the CPC. Our submissions by the various councils point to that direction in adequate words. And it is important that the court only invites the accused to plead to a charge that discloses the course of action. And we have shown the mismatch between the offense charged and the particulars. I need not go beyond that. But when you retire to make a ruling, should you require more time, we urge you to consider releasing Mr. Morara, who is, I'm informed, is an officer of this court, on a personal bond. He is, I'm informed, he's not an officer of the court, but he is a person who is well known, has a fixed abode in town, and he is not a flight risk. You may consider releasing him on a personal bond, because we must not encourage the behavior of the police of punishing people in advance of appearing before the court. By punishing, I mean detention, unnecessary detention. He is a person who can actually be released on free bond, and we are many, and we will make sure he appears.
Investment, contrary to section 27 of Computer Misuse and Cyber Crimes, Act number 5 of 2018. Dated on the 28th day of September 2024 at a known place within the Republic of Kenya, jointly with others now before court, while using X-Corp account dumped at Morara, Cabason Senior, you knowingly, without lawful excuse, posted false information to it. I quote, William RUTO approached DL Langat and told him he desperately needs more money for campaign. DL Langat used his property as security and took big loans to help his friend. Right now, DL Langat is being auctioned by banks, and the person who is buying the property is William RUTO. To make it worse, William RUTO has used his powers to undervalue the property to buy them at a cheaper price. That is the kind of a person we are dealing with. He has no friend. Contact whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Langat. Is it true or not true?
Before he pleads, it looks like there is a mismatch in the charge sheet, and that it may not be worthy of pleading to. So I will be asking you to reject it under 89. If you look at the charge sheet and the particulars, if at all any name was to be tarnished, probably it would be that of William RUTO, if the particulars were not true. It would not be the name of David Laka. So what is the fear of putting the name of William RUTO as the complainant? This is a very, and you can see, I don't know if it has been drafted, but if there was a name to be tarnished here, the person who is looking like ungrateful and not quite a friend would be William RUTO. So I'm urging the court to read the charge carefully and reject it, because it doesn't, something is not adding up to this charge sheet. Even if we go to trial on this, and even if David Lagat comes, it will not be sufficient without William RUTO as the complainant.
Yes, Your Honor. Just to be precise on what senior counsel.
Just a moment. Yes, Mr. Ndegwa.
Yes, just to be precise on what the senior counsel submitted on, there is no doubt that the particulars of a charge sheet are to be able to inform the accused person what he or she is pleading to. And that the particulars of an offense as particulars must speak to the alleged offense. They must clearly square out the subject of the complaint to which our client has been brought to you to plead is one Mr. William RUTO. And therefore, if the offense as drafted was to have any meaning in law, to the extent that our client is able to respond either positively or negatively, the particulars must relate to the subject. To that extent, Your Honor, this charge sheet is defective. It is not worth the paper it's written on. And our client is not able to plead it as the particulars do not inform on how to should be. It does not disclose who is the complainant. Is the complainant Mr. William RUTO, or is it D.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's all, Your Honor.
Your Honor, if I may.
Proceed from there.
You're welcome.
You're welcome. Madam, is someone...
And perhaps, Your Honor, there are two people who should just be brought to offense. It is Morara and Ndegwa.
Oh, okay. So whoever has not been brought should be brought so that we clear with them. We have so many witnesses today. We'll finish as soon as possible. Stop. Why your case has 10 witnesses? We have another one at 2 also. So I don't expect plea to take more than 30 minutes. It should be what it should be.
If only they could have been waiting since morning, and we are wondering whether now the prosecution is also punishing counsel by keeping us here this morning.
Call it out again, please.
Criminal case number E1020
Good to see them when they come.
Your Honor, eventually they will have to expand this court.
The room is spacious enough.
And I don't think they can expand the court as the prisons.
You can try and settle out there so that you don't have to come here. That way we will not have to expand. See, now we can't just sit waiting for a person to be brought when we have others waiting here. Yes. This is the matter we confirmed.
1676 of 2019.
Have been set up. I will now not be writing, but please, when you speak, say your name at the beginning and use the microphone. Yes. So we have them transcripted.
With the very kind permission of the matter, my name is Morara, and I wish to address the court as follows. I'll pick it up from where my learned senior Mr. Otieno left it, and urges to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. You know, that is under Article 25C of the Constitution. Very quickly, Your Honor, I'll, with humility, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, Your Honor, is about the right of the accused person to be informed of the charge with sufficient detail to answer it. But, Your Honor, what has come out in the few minutes before?
That should be 50 sub-article.
50 sub-article 2B. If I'm not wrong. Your Honor, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J, 52A all through to 50Q, Your Honor, is what constitutes fair trial. Something that, Your Honor, as we stand before you this morning or afternoon, the accused person is clearly not able to understand, Your Honor, what he's responding to. And these are provision, Your Honor, or these are right, Your Honor, which cannot be limited. I invite court to find basis on those two articles, Your Honor, to reject the charge sheet that have been read out. That's all from me.
And the particulars. The contention, especially my senior colleagues have raised, is what is harassment? Your Honor, I look at that particular act, the Computer Misuse and Cybercrimes Act. It does not in any way define what harassment is. Harassment takes various forms. For one to draw a conclusion that harassment has occurred. The particulars in the charge have clearly informed the accused person of the accusation that he is facing. And what my colleagues are asking me to do is to go to the substance and the merits of the charges, to go to the evidential material. As at this point, Your Honor,
Just a moment. Yes, Mr.
as at this point, what court ought to consider that the particulars of the charge have sufficiently informed the accused person of the accusation against him, which in our humble view are sufficient to enable him respond to the charges. To delve into other issues, Your Honor, would be going to the merits and demerits of the particular matter. I do understand the constitutional issue that have been raised by my senior colleagues. And those issues cannot be raised as at this point. The only purpose we are here for today is purposes of the charge sheet, whether it has statement of the offense and the particulars of the offense, and other considerations. Refer this court to section 137 of the CPC. Your Honor, the last point that Mr. Ndegwa has raised on the issue of the 3 phones and 1 laptop, I undertake to follow up the issue with the investigating officer to find out if they are interested in the material or the same should be released to the accused person, and undertake to inform him before the closure of business today as to what the response of the investigating officer has been. Luckily, I have Mr. Ndegwa's number. And also Mr. Eric Peuri. Surprisingly, the squatter from Tuapa has not spoken. I'm sure he will respond.
I humbly and well associate with the mission of my last seniors. I thank them for the knowledge that I've received. However, there's one small thing that they haven't touched. And briefly, that's to do with the framing of charges under section 134 of the CPC, procedure code, as read together with section 135 of the criminal procedure code, which dictates in mandatory terms that a charge must contain a statement of the specific offense with which the accused is charged, and enough information to demonstrate the nature of the offense. Much has been said about civil defamation. Civil defamation. However, in brief, Your Honor, if you see count, it refers to cyber harassment under section 27 of the Computer Misuse and Cyber Crimes Act. However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer Misuse and Cyber Crimes Act. Specifically section 22 of the Computer Misuse and Cyber Crimes Act. If you go on further, Your Honor, they have repeated the statement, false, again. And then lastly finished with calculated to tarnish and discredit. Calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or to civil or defamation? Your Honor, in brief, as I associate with what my learned senior counsel Eric Peuri stated, I was with Morara when he was being arrested. The police refused to grant me access under Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. So, Your Honor, the question is, we are dealing with people.
Sorry. We might all of us end up painting here. So please, just a request that you allow us to manage the crowd. I'm going to request everybody after the gentleman with the big camera. We're just going to ask you kindly to step out of the room. Otherwise, we all face here. And I think we make arrangements Please, you can listen from outside. We have speakers, so you'll be able to listen. See how if you have problems with that, you just have to break. Because health comes first. Please, please. Okay, want to see you council speaking.
Oh, yes, yes, sir. So,
Because you can get, there's so many of us are sweating. You can get the smell of sweat.
And the shoes.
yes, Your Honor, I'll be brief. Your Honor, in
How
brief,
many more minutes will you take?
3, 4 minutes.
Okay.
That's too much.
Your Honor, in brief, what we're witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you're not a witness. So you are yet to take plea. Yes.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal one. He is a young person, he is a young person. To release, to free him, free him of discharge him. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, Your Honor. Fellow Gen Z. And we will stand with him.